This morning, we are going to talk about proving participation. It will be all about evidence of contribution and causation. And to chair this panel is Professor Donna Zapa-Gasgonia, who was also here yesterday. So she's again doing double duty like Ma'am Gertie yesterday. So Professor Donna graduated from UP College of Law. She received her Master of Laws degree from Canada. She's an AB Philosophy cum laude graduate of the UP College of Arts and Sciences. She's a practicing lawyer and she supervises the Environmental Litigation Clinic of the UP Law Clinical Legal Education Program. She is a lecturer at the UP Law Center Institute for the Administration of Justice, MCLE, on the subject of prosecuting environmental cases. So, yes, Ms. Donna. Joining Ms. Donna are the following panelists. First, Professor Rommel J. Casis, who received his LLM from Columbia University in 2010. He specialized in international law, climate change law, and environmental law. He teaches environmental law and policy in the LLM program of the University of the Philippines and public international law in the JD program. In addition to teaching full-time, Professor Casis is the director of the Institute of International Legal Studies of the UP Law Center. As director of the ILS, he is involved in and supervises various research projects involving international law, including but not limited to international environmental law, international humanitarian law, international trade law, and most recently, space law. In addition, he is also the advisor of our debate teams, and they won this year the Stetson and the Jessup Moot Court competitions. So, ladies and gentlemen, Professor Casis. Another panelist who is in the theater today is Dr. Jem B. Castillo. He is a distinguished expert in resource and environmental economics with a PhD in forest economics from Michigan State University, an MS in forestry, and a diploma in development economics from the UP, along with a BS or Bachelor of Science in General Forestry. He currently leads as president of the Resources, Environment, and Economics Center for Studies and the Resource and Environmental Economics Foundation of the Philippines, Inc. Additionally, he is the National Director of the Economy and Environment Group, Philippines, and a member of the Executive Committee for the Economy and Environment Partnership for Southeast Asia. He has extensive experience in national capital accounting, valuation of ecosystem services, and economic impact analysis. His work includes consulting for the Philippine Development Plan 2023-2028 and leading projects funded by the World Bank, UNEP, and ADB. He has evaluated mining operations and developed capacity building modules in ecosystem and natural capital accounting. Sir Jem, would you join Professor Donna up on the stage, please? Thank you. Now, our third panelist is Attorney Pochoy Labog. He is a Southeast Asia researcher and representative of the Business and Human Rights Resource Center. Prior to joining the center, he was the Legal Services Coordinator of the Legal Rights and Natural Resources Center, or Friends of the Earth Philippines, where he led the litigation of cases aimed to advance the rights of indigenous peoples and upland rural poor communities. Pochoy holds a JD from the Ateneo Law School and an LLM in International Legal Studies with a certificate on International Human Rights Law from Georgetown University Law Center. Ladies and gentlemen, Attorney Pochoy. Now, joining us online and also doing double duty because she was here yesterday, again online, is Advocate Moumita Das Gupta from Bangladesh. She is an advocate affiliated with the Supreme Court of Bangladesh and working as a research fellow of Center for Climate Justice. She has completed her LLB and LLM from the University of Chittagong And she worked with Bangladesh Legal Aid and Services Trust as a Community Justice Fellow. She is providing voluntary services to the Sabin Center for Climate Change Law as the National Rapporteur on Global Climate Litigation, representing Bangladesh and co-leading Asia as a regional leader. So she's joining us online. Another panelist who is joining us online is Attorney Hiroyuki Kita. He became a lawyer in 2005, having registered in the Osaka Bar Association, and he serves as a legal advisor of the Taken Association. He obtained a qualification of rental real estate management in 2020, and they established Keiko Kita Law Office in 2023. He is a part-time lecturer at Osaka Public University as well as the Kyoto University Law School. So welcome, Attorney Hiroyuki Kita. Another panelist joining us online is Sejong Youn. He's the director of Plan 1.5. It's a non-profit climate organization based in Korea and is the counsel for the Korean Youth Climate Litigation, which is the first systemic climate litigation in Korea. Sejong was involved in many climate litigations in the jurisdiction regarding coal power plants, public financing to fossil fuel projects, and airport expansion permits. Before joining the civil society as a climate activist in 2019, he practiced law at Kim and Chang, specializing in environmental law and international arbitration. And finally, another panelist who's joining us online is Nobuo Kojima. He was admitted to the Tokyo Bar in 1984. He's a partner of Tokyo Surugadai law offices, and he was involved in coal thermal power plants problems in the Philippines. He is a professor of law at Waseda University Law School, and he was part of a panel of Nuclear Damage Compensation Dispute Resolution Center in Japan, and he was leading attorney for litigation against Yokosuka Coal Thermal Power Plant. So very impressive credentials of our panelists today. So I give everything to you now, Professor Donna.
Thank you, Attorney Froy. Good morning, ladies and gentlemen. Welcome to the panel 3 of this conference. So since we're not given much time, we have to immediately start. We will ask our panelists for opening statements to keep it at least 5, preferably, but of course we will be flexible. So I will call it from the panelists who are here first, and then we will go online to make it more facilitating, easier for the IT also. So may we call on Dr. Jem Castillo. I think he wants to use the podium with slides, please.
I have a very simple slide. Without any Filipino designs for slides, which is, many of us are fond of. But I call this presentation the contribution of the environment and natural resource economics to litigation. So I have only 5 minutes, but I have 10 slides. And I'm the only non-attorney in this panel, so I'm afraid I won't be able to, we use a different language in environmental economics. So just a summary of the methods and processes that we do. Of course, I will not be reading all of them, but giving you an opportunity. Essentially, of course, when we are asked for evidence, then therefore the first step is define what we want to gather. And then we apply modeling. For first instance, we do biophysical modeling, and for the climate change negotiations and estimation, we have quite a number of models. I have a list at the last page in a way. And after that, we do quantification from an economic perspective. When we say quantification, we actually are putting monetary values to it. And then once, because of the demand, especially for compensations, so the question is, for instance, if it's damage to an ecosystem or damage to an environmental natural resource, we do estimate how much is the unmonetized by converting them into monetary values. So, and then of course, we try as much, although we are not really into the legal aspect, we do integrate in economic analysis in legal policy. So sometimes they ask us for policy instruments. Beyond the policy instruments is what can we do to help support litigations, so on. And of course, we're talking about causation and attribution. So the first question that we ask us is there a direct link? And that means we have to develop attribution models. And so we have what we call the integrated assessment models. Sometimes the integrated assessment models are basically physical, but we transition towards economic models. And so we do data collection and analysis. We need the experts from other disciplines, collaborate with data collection experts, and quantify the impact of the corporation or the entity committing the challenge or the issue. And then from the economics perspective, we do valuation. And quite a number of tools for valuation, but for damages and compensation, we do estimates of damages and or avoided damages. Then we perform economic analysis, econometric analysis, and then we do trade-off analysis such as benefit cost analysis. But the benefit cost analysis is not from a firm's perspective, but it's typically from a society's perspective or a public interest perspective. But as we know that because if the environment and natural resources, there are stochastic activities and events, we do combine it with uncertainty analysis, including risks analysis. For attribution science, we have to demonstrate the connection between the specific activity and the environmental impact. And I will not dwell so much on it. Essentially, we combine statistical methods, econometric analysis, and probability, especially if we're talking about uncertainties. And so, for instance, this is an example. A friend of mine sent me his article of using different disciplines. It's really a collaborative work of foresters, ecologists, social scientists, math statisticians, to translate to economic values using damage function approaches. For instance, they were able to come up and identify places and locations. So the tools in economics has actually expanded. We're now talking about spatial cost-benefit analysis because of the improvements in technology and so on. And here is an example that I use for one company who is interested in addressing the issue of impact of jetty construction. So when you think of jetty, also think of it in terms of Manila Bay reclamation port. So you have to really trace from the specific activity to what is its impact on the resource or the environment and natural resource, both at the biophysical, all kinds of economic media, and how it leads to values in economics. Because you have to first understand the physical content of that, translate them into impact on services, ecosystem services, and the ecosystem services affected, translate them into negative or positive contribution. Then, of course, here is an example of how I had to do it. First, I have to do some compilation of data or data collection, do a statistical analysis, and from the statistical analysis, quite a number of tools and methods. For instance, in this case, fishery, impact on fishery, not only fishery, but also like live fish capture or recreational fishing. So you have to take them into account. And from there, you estimate how much is the loss of harvest in fishery and how much is but the harvest in fishery, because of course in these uncertainties, you have to introduce uncertainty, and the tools that we use is basically simulation. And these are the examples. And then, from the economics perspective, we think about how to put value. And so we employ economic valuation techniques, but you have to take into account that there are valuations that are not right now acceptable from economic accounting perspective. For instance, if we're talking about GDP in the Philippines, it does not capture welfare-based valuation methods. What is only accepted from an economic accounting perspective is what we call exchange valuation, meaning there is a transaction that's visible in the market. So we call it exchange valuation. But there are other values of environment and natural resources that are not accounted for. And so we do welfare-based valuations, or we call it non-market valuation. And there are separate tools for that. We call it revealed preference approaches or the stated preference approaches. And one of the things that we have to think about is the valuation of sustainability. A lot of people are talking about sustainability, what we should be able to translate in economic terms. I remember that during the time of Attorney Donna Gasgonia, there was an issue about intergenerational equity that was filed by Attorney Posa on that case. So giving enough resources for the future generations, and it went through the Supreme Court, and I think Attorney Donna would are more familiar with it, but something that we have to think about if we're talking about intergenerational equity. So these are the methods and tools that we use. Also already internationally applied, and these are the tools that are being used by intergovernmental panel for climate change. And so quite a number of models, some of them have been used and applied in different court cases or litigations, and also not only in litigations, but also imposing regulations. So two aspects. One is improving regulations, imposing regulations, or addressing issues in terms of litigations and so on. There are different methods. So we have the DICE model, that's very common in IPCC panel, the PAGE model, or the policy analysis of the greenhouse effect, the GCAM, or the Global Change Assessment Model, the AIM model, or the Asia Pacific Integrated Model, and the MESSAGE model, and so on. So these are the tools for integrated assessment models, but you will take note that not many of them have monetary valuation. So we have to translate them into monetary values because of the issue of finances or compensation, in monetary compensation. So the tools that we use, for instance, is the cost-benefit analysis, just like what we did for Manila Bay reclamation. So, but we know that when we do cost-benefit analysis, we're just dealing with beyond impacts on individuals and firms. It has to do with impacts on public interest or society's perspective. So that means impacts on the economy, impacts on the society, and also impact on the environment and natural resources. The other tool that is common in the climate change arena is damage assessments for compensation. So damage to crop yields, property, health, and so some of the tools that we include, like those response functions, loss of ecosystem asset using natural capital accounting, climate change damage using avoided damage methods, and species loss or fishery damage. So these are the, in an area where there's an issue, we have to identify which of these economic activities are actually affected by any particular activity. And so tools for environmental and natural resource economics would include benefit cost analysis, natural capital accounting. Attribution science is typically applied in climate change. Valuation of ecosystem services. So you may have already heard that we have just recently enacted into law the Philippine Ecosystem and Natural Capital Accounting System, actually enacted during my birthday, so in May. So that's because that's my area of expertise as well. And we also economic impact studies, and we're trying to incorporate now benefit cost analysis in environmental impact assessments, because we think that environmental impact assessments are weak in terms of the monetary valuation and so on. So there's now a move in both, I think, upper and lower house to take a look at the provisions of the environmental impact assessments in terms of its impact on environmental issues. I think that's the end of my sort of presentation. Thank you.
Thank you, Dr. Jem Castillo. I started taking down notes like a student when I was there at UP Los Baños. Then I stopped myself to remember, wait, I'm chairperson now. So I was putting so many words here. But those were wonderful memories at UPLB. And then the traumatic subjects he had to mention, which I was telling him earlier, talking about economics, benefit cost analysis. We called it social benefit cost analysis at SESAM before. Natural capital accounting, we referred to it as natural resources accounting before. But so many things have happened, and he mentioned that there is a law now on NCA, so that's the PENCA. So we're very much looking forward. Thank you so much. He also told us about EIA, which is a very, very important system in the Philippines. So now that leads us to our next speaker, our own Professor Rommel Casis, and he will tell us about a very important principle that we use in environmental litigation. Sir?
Thank you, thank you, Donna. All right. I hope you don't mind that I will be speaking from the podium so I can see the audience and so I don't also have a stiff neck looking at the background. Let me begin with a confession. When Mike first asked for me to be part of this, I said, I don't think I have anything to contribute, not being a litigator. But since he was insistent, maybe I can talk about the precautionary principle. Maybe that would be significant. And true enough, Justice Youn yesterday did mention this as the second issue or question that need to be addressed when it comes to climate change litigation. So let me begin first with something I am comfortable with, which is international law. As we know, precautionary principle is a principle under international law, although it did originate first as a domestic law principle in Germany. But now it is an accepted principle under international law. Of course, its status, whether it's customary or a general principle of law, is still up for debate. What it normally and usually it is described or defined under Rio Principle 15. I'd like to read this because I think it's significant for the entire thing, what I want to say in my presentation. It says, in order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. Principle 15 is usually the international law definition for the precautionary principle. If we break it down, as I do in my classes, what can we see in the Principle 15? First, the general statement that it should be widely applied. What is the trigger? And I want to stress this. The trigger for the precautionary principle under international law would be threats of serious or irreversible damage. That is what you need to prove. That's what needs to exist in order for the precautionary principle to apply. What is the effect of the precautionary principle? Under EU 15, the lack of scientific certainty shall not be a reason for postponing action. And that's something that needs to be remembered, especially when we're analyzing climate change litigation. According to scholars, perhaps the most well-known is Burney and Boyle in their book. They describe that the main effect of Principle 15 in international law, therefore, is to lower the standard of proof of risk, where there is some evidence of risk. So there has to be evidence, but some evidence of risk, then the precautionary principle is triggered. Now let's leave international law and go to the precautionary principle under Philippine law. Now, what's interesting is that the precautionary principle, I must say, has been accepted in the Philippine legal system. The international law principle, I mean. A few years ago, I wrote a paper that was published in the Philippine Yearbook of International Law, which outlined the Philippine practice. And even then, there were many statutes, administrative issuances, Philippine cases that deal with precautionary principle. And since that time, and I think in the last 6 years or so, there has been more rules, more cases, more laws. So we've grown in our acceptance of the precautionary principle. These are just some examples of the laws that refer to or use the precautionary principle in applying the obligations under the statute. This is not exhaustive. You have administrative issuances. There are many. So what I've just placed there are the different agencies of government that have issuances that employ the precautionary principle. And then you have Philippine cases, also non-exhaustive. Some of these cases, they were discussed yesterday by Justice Youn. And then you have the environmental rules of procedure. Now, Section 4F of the revised, the rules of procedure for environmental cases defines the precautionary principle in this way. Now, I'd like us to compare the two versions, Rio Principle 15 and Section 4F. There's a difference, and there's a reason for this. When the environmental rules of procedure was being written, I was the substitute of then Dean Youn in the committee. So I was there when the rule on precautionary principles being discussed in the committee. And the version of the precautionary principle that was used was not Principle 15. It was the Wingspread Declaration. And now, if you look at jurisprudence, this is what is sometimes referred to as the strong version of the precautionary principle. In international law, there are three ways of interpreting the precautionary principle. The passive, or what we now call the weak version, which is the absence of scientific certainty is not an excuse for inaction, which is Principle 15. Then you have the active version, or what is now known as the strong version, which is the absence of despite the absence of scientific certainty, there should be action. And then you have the third version of the precautionary principle, which says that when the precautionary principle applies, the burden shifts to the project proponent. All three versions can be found in Philippine jurisprudence, incidentally. Anyway, but notice the difference. In Rio Principle 15, it's serious or irreversible damage. Under our rules, it's serious and irreversible damage. It's a higher threshold. It's also, notice that in the Rio Principle 15, scientific certainty is not a requirement. It's not an element. But in our rules, the presence of scientific uncertainty is an element, and you can see that in the jurisprudence. And you notice also the difference in the effect. The effect in the Rio Principle 15 is you can't use it as an excuse. But under our rules, the effect is you should take action. So you see the difference, how our rules of procedure applies the precautionary principle versus the international law principle. Notice also in Rule 20 of the Rules of Procedure for Environmental Cases, ironically, if you read it, it seems to be closer to Principle 15 than the Wingspread Declaration. It doesn't say should take action. It only says shall apply the precautionary principle. So I guess you would think, well, the precautionary principle as defined under the environmental rules of procedure. But the initial part, Section 1, seems to follow more Principle 15. And that seems to flow also from the second paragraph, which seems to create a presumption for the benefit of ecology. And then you have Section 2, which provides for the following factors. I don't think that these factors should be considered as elements of the precautionary principle, but it's just our rules to help judges determine the application of the precautionary principle. So let me end with this, since I only have 5 minutes, and hopefully I did not go over time. Let me summarize by saying that the relevance of the precautionary principle can be seen in two areas. The first is, if you apply the strong version of the precautionary principle, it can be a reason or a legal basis for action. If the precautionary principle is triggered, then the government should regulate, then the corporation should take action. Of course, since these are just, if you are going to apply the environmental rules of procedure, you need to connect it to a substantive law which provide for the obligation, right? Because the rules of procedure is just for evidentiary purposes. The second relevance in litigation would be that it lowers the standard of proof. If it's a civil case, then it would be preponderance of evidence. The problem is what does it mean that it lowers the standard of proof? I think this is where this is the problem in some of the cases that we have so far. The other way we could apply the precautionary principle, and we also have it in jurisprudence, is to shift the burden of proof to the project proponent. I used to teach tort law. Now I've handed over that subject to Professor Mike Chu. And the precautionary principle is very similar to the principle of res ipsa loquitur, which shifts the burden of proof to the entity which caused the damage, given that the elements of res ipsa loquitur applies. So it's very similar. There should be no problem to apply the precautionary principle as a way of shifting the burden of proof. The cases that discuss the precautionary principle under Philippine law, they're quite interesting. They offer opportunities, but there are also obstacles on the basis of the current cases. But since I don't have time to discuss that, I won't get into that right now. Thank you very much.
Thank you, Professor Rommel Casis. So thank you so much for that. I think we're very fortunate to hear from one of the authors of that particular provision on precautionary principle in the Philippine Rules of Procedure for Environmental Cases. He also highlighted to us the importance of finding the intent of the authors of those principles. So here we have statutory construction that we should not forget when we deal with, among others, environmental cases. So actually, Prof. Rommel, we should have a special lecture on exactly this one, because precautionary principle is becoming a very, very important tool in environmental litigation. And your take on that was so opening our minds to what you really meant when you had that precautionary principle in the rules of procedure. So now we move on to Attorney Pochoy, Labog, and I think he will present it from the couch.
Thank you very much, Professor Donna. Before I start, I would just like to say that it's a pleasure and a privilege for me to be part of this panel. 20 minutes in, I'm already learning a lot from my co-panelists, starting with the need for collaboration with other disciplines when it comes to climate litigation, because as lawyers, we're sort of the directors of the case, how the case will proceed, but we need help in proving our cases. And of course, I wasn't even thinking about this, a precautionary principle, what a way to sort of frame our discussion. It's lowering the standard of the proof of risk, sort of like erring in the side of caution. That's how I appreciated it. And this is very important, considering that the odds are stacked against vulnerable communities and the environment when it comes to claiming for damages, for impacts of climate change. So I would venture to say that this should inform all our courts and the lawyers that are participating in cases. And I'm reminded also of the sort of with the the human rights field, lowering standard of proof. This is also present in the writ of amparo, where it's actually not just lowering the standard of proof, but shifting the burden of proof to in writ of amparo's case, state agents that are alleged to have committed crimes, because again, recognizing the challenges, the insurmountable challenges that face claimants in these types of cases. I sort of went off the rails there. I was so inspired by the opening remarks. But just very quickly, I'm from the Business and Human Rights Resource Center. I I haven't been litigating for some time now, or more. I'm more of a researcher. So the Business and Human Rights Resource Center, we are an international NGO that tracks human rights violations that are linked to business. And we're present in most countries around the world, and I am the Southeast Asia researcher. So next slide, please. I told the organizers that I'm not really a climate expert or climate litigant, and my field really is in human rights, particularly indigenous people's rights. But I mean, climate cases are based on human rights, specifically the right to a healthful environment, or in our jurisdiction, the right to a balanced and healthful ecology. So the Resource Center, we also track the developments in climate litigation. And this is one of the stories that that is posted in our website, that in recent times, this is a study just recently published. So this is Global Trends in Climate Change Litigation 2024, just this year, a snapshot. So there's been a significant rise in climate-related lawsuits against companies. So this is since 2015. So at least 230 new climate cases were filed in 2023. Many of these cases seek to hold governments and companies accountable for climate action. And the most successful type of case is the climate washing case. So this is a form of greenwashing. So cases that challenge the inaccurate government or corporate narratives regarding contributions to the transition to a low carbon future. So for this year, 47 cases were filed. And so these cases have 70% of them have been completed, and most have been decided in favor of the claimants. Next slide, please. But again, this is just based on recent research. These are the types of cases, climate cases, not at all an exhaustive list. The first is compelling governments and corporates to reduce greenhouse gas emissions. An example of that would be the Milieu Defensie versus Shell case. Milieu Defensie is also Friends of the Earth, just like LRC, where I used to work. So here the plaintiffs sought a ruling from the court that that Shell must reduce its carbon emissions by 45% by 2030 compared to 2010 levels, and to zero by 2050, in line with the Paris Climate Agreement. And the other type of case is preventing financing. So this is more of a prevention type of case, preventing financing and construction of high-emitting infrastructure. So before these infrastructure are mounted, these cases are filed, sort of an injunction case. And the third would be, I would say, the hardest, most difficult one to prove is the damage liability cases. So these are the cases where the plaintiffs seek to be compensated for the damages or losses incurred as a result of the defendant corporation's greenhouse gas emissions. So next slide, please, just to illustrate. And I will sort of compare this with a typical human rights case. So here, as you can see in the diagram, so country A, I just say country A, and mostly these are countries in the global north that have heavy emissions, carbon emissions. And the chain is just a longer chain, I would say, compared to longer chain of events compared to a typical human rights case, and involves a multitude of factors. So the emissions come from, say, country A, which is in the global north. It affects those are clouds on top. It affects the climate, and with the effect of the climate, there's global warming, and there are certain events that transpire with with climate change. It can be sea level rise, storms, flood, and as a result of these events, communities are impacted in country B, which may be found in different jurisdiction, typically in the global south, although we see effects more and more happening everywhere. Compared to a typical human rights case, for example, land grabbing, it's much more direct. The chain of relationships is much more direct. And to navigate this complex chain, we need the help of science. And Professor Dr. Jem already mentioned the use of attribution science in sort of proving our cases to claim damages or loss against carbon emitters. I think I can end there. Thank you.
Thank you, Attorney Pochoy Labog. And so we have a more global approach through your research. Now we have, so this brings us to our online panelists. So we would like to call first Attorney Hiroyuki Kita, if we can have him online, please. Attorney Hiroyuki Kita.
Hi.
Yes. Good morning, sir. Please.
Good morning. Can you hear? Good morning, everyone. My name is Hiroyuki Kita. I'm attorney at Kita Law Office in Japan. I am honored to be here today to discuss the Kobe case and the legal challenges associated with providing corporate contribution to climate changes. Wait a few minutes. See the presentation. Can you see? Okay. My presentation will focus on the overview of Kobe case, the challenging establishing causation, and our strategies to overcome these challenges. Self-introduction. Overview of the Kobe civil case. The Kobe case involved both civil and administrative litigation, but today I will focus on the civil case. Kobe case constructed a new coal-fired power plant with a capacity of 3 million and using pulverized coal conversion and ultra supercarrier technology without carbon capture and storage (CCS). Without CCS. The plant began operation in 2021 and 2022, located in Nadaku, Kobe City, near a densely populated residential area. In 2018, 40 local residents, including 6 children, filed a lawsuit seeking to halt the construction and operation of the plant. They argued that emissions from the plant would infringe on their personal rights and peaceful life by increasing pollution levels and contributing to climate change. Summary of the Kobe District Court judgment. A major challenge in the Kobe case is proving the causation between the plant's CO2 emissions and the adverse impacts on the plaintiff lives. The first instance court recognized the impact of CO2 emissions and the possibility of the claim for an injunction based on climate change. However, it don't recognize specific danger to plaintiff or causation between climate change, induced disasters and their harm. Lack of specific danger. Point or at issue of the judgment. The lack of specific danger was the major hurdle. To address this, we restructured the concept of personal rights to include the infringement of climate change-related personal rights. This considers the necessary for the plaintiffs to live their daily lives, preparing for climate-related disasters, even if they have not directly faced such disaster yet. Legally, we argue that the requirement of specific danger is unnecessary when claiming infringement of climate change-related personal rights. The construction of climate change-related personal rights is based on the Paris Agreement and the 1.5 target. The concept of the carbon budget to achieve carbon neutrality by 2050 underpin our argument. We argue that CO2 emissions exceeding the carbon budget are illegal as they infringe on personal rights by contributing to climate change. This approach broaden the scope of personal rights infringement to include the need of individual to adapt their daily lives. The increasing risk of climate-related disasters. In Japanese courts, the acceptance of expert testimonies is limited. Typically, only one or two expert witnesses are permitted to testify in the first instance. It is almost unheard of for all plaintiffs to be questioned. Instead, only a few representatives are allowed to testify, while others submit written statements. Furthermore, the corporate defendants often do not do not uh, uh, do not actively review the plaintiff claim, relying on the inherent difficulty for plaintiffs to prove causation and the specific dangers associated with climate change impacts. Thank you very much. 何でしょう。Thank you very much.
With another Japanese expert, we have Attorney Nobuo Kojima. So may we please hear from Attorney Kojima? Is he online already? So that we will have a more comprehensive picture of the Japanese situation? Yes, sir. Mr. Attorney Kojima, please, your presentation.
Thank you. Thank you very much for inviting. Can you hear me? Thank you very much for inviting me to this very important conference. Today, I'd like to discuss only on causation problem between the plaintiff's specific damages and a specific facility which emit a lot of amount of carbon dioxide. Tokyo District Court 2023 said it is difficult to recognize that carbon dioxide emitted from the new power plant alone will significantly increase the scale or frequency of damage from disasters of global warming. Tokyo District Court denied the causation between the emitted carbon dioxide from a new power plant and climate change. They used the word alone. We discussed that global warming is caused jointly, but the district court want to use the word alone. And the annual amount of carbon dioxide emissions from the new power plant, when this new power plant operates, is about 1/5,000th of the global emissions, and about 0.464% of the total Japanese emissions. We think 1/5,000th of the global emission is great amount, but the court think it is not a big one. So the court think the carbon emission from the Yokosuka coal thermal power plant is a teardrop in the ocean. But we think it is the last straw. So, compared to the toxic air pollutants such as SO2, it occurs locally, and contamination is the most severe at the source, and you as you move away from the source, the toxic substance is diluted and diffused, and the global concentration becomes so diluted that the impact is negligible. And the environmental impact is reduced to a negligible level. But CO2 and global warming, global carbon dioxide concentration are already high. It is at a level that could cause a major climate disaster. In this respect, it is already a heavy enough load on the camel's back. It's a heavy enough load on the camel's back. CO2 in the atmosphere, how do we decrease? This is the Japanese government explanation to AR5, IPCC's appraisal report, fifth appraisal report, working group SPM, summary to policymakers. As for anthropogenic carbon dioxide, once emitted, it circulates through the atmosphere, ocean, and ecosystem over a very long period of time, while the total amount of carbon hardly decreases. A certain portion remains in the atmosphere, and radioactive forcing persists. Almost same thing are written in the IPCC report itself. A large fraction of anthropogenic climate change resulting from CO2 emissions is irreversible on a multi-century or millennium timescale. Depending on the scenario, about 15 to 40% of emitted carbon dioxide will remain in the atmosphere longer than 1,000 years. Carbon dioxide will never disappear, continue to exist for a long period. And even after carbon dioxide emission is neutralized, that time surface temperature may neutralize, constant. But it's constant at elevated level for many centuries. Even after that, a complete cessation of net atmosphere of carbon emissions. Due to the long time scale of heat transfer from the ocean surface to depths, ocean warming will continue for centuries. So even after the surface temperature become constant, even after that, the climate change will continue, and it may cause more disaster. It is the situation. Stabilization of global average surface temperature does not imply stabilization for all aspects of the climate system. Shifting biomass, soil carbon, ice sheet, ocean temperatures, and associated sea level rise all have their own intrinsic long time scale, which will result in a changes lasting hundreds to thousands of years after global surface temperature is stabilized. It is clearly written in the fifth appraisal report of IPCC. So already we are in this situation. Emitting carbon dioxide into the atmosphere, already this is the situation where it is already in crisis. Will certainly increase atmosphere carbon dioxide concentration, will certainly increase surface temperature. will certainly increase ocean warming, will certainly advance climate change, and will certainly cause more serious damage to people's lives and livelihood. So we think it is the last straw. Now, carbon dioxide emitted from a new big facility such as coal thermal plant is the last straw. So we should stop it. But unfortunately, Japanese government think and Japanese court think it is not the last straw. It is a teardrop in the ocean. So our task is how to understand the Japanese government to that it is the last straw. It is the end of my discussion. Thank you very much.
Thank you, Attorney Kojima. And there we have the two Japanese experts telling us first. Attorney Kita told us that maybe there is scientific evidence that can be presented in court. The problem was they did not have enough experts to testify on those documents. And maybe that's the same for most of the countries represented here. Attorney Kojima, on the other hand, alerted us to the importance of surface temperatures and ocean warming. And this is very important to the Philippines, also an archipelago, where climate change will impact the oceans, and we will be, as an archipelago, really affected at that level. Thank you very much to our Japanese experts. This opened the discussion on climate change again. Perhaps we should look at that, Attorney Casis, on ocean warming. I haven't really encountered that, not as much as just a small waterway or a local waterway, but ocean warming per se. So now we're ready to listen to another an expert from another country. May we call from Korea, Attorney Sejong. Youn, please, Attorney, if we can share we can see you online. Yes, Attorney, please share your presentation with us.
Thank you. Thank you. It's a great honor to be part of this program. And I am going to talk briefly about the Korean youth climate litigation and what the issue of causation had to do with this case, and also potential corporate litigations on climate change. So Korean youth climate litigation was a framework litigation. A group of teenage youth plaintiffs were suing the government for not acting enough on climate change, and that is creating an infringement of their fundamental rights violation. One of the key causation issue we had in mind from the beginning of this case is that we didn't want to frame this as individual harms, because that will naturally invite questions on the specific causation between the climate change and the claimed harms of the individual plaintiffs. We characterized it as a general human rights issue, fundamental rights violation with the ongoing climate change. And that was possible because it was a constitutional case. The plaintiffs were asking for a declaratory relief, saying the law and the regulation is unconstitutional as an abstract statement, instead of ordering a specific private party or the government to take specific action. But this question becomes a little bit more tricky when we are trying to plan a corporate litigation, which we haven't yet, and causation is one of the key obstacles to it. So the court has been applying proximate causation test to all environmental harms, and I think that's quite aligned with the examples of we heard from Japanese colleagues. So there are 3 steps that the plaintiffs need to prove. One, there's an emission of a pollutant, and the pollutant traveled, and the plaintiff was exposed to the pollutant, and that has caused harm. So for example, if there's a factory creating SOx and NOx or particulate matter pollution, and if there was a wind blowing in the direction of the plaintiffs, and if it caused damage to the crops or to the people, and that would be the harm. And those were the 3 steps that will need to be shown. But in case of climate change, the most different part, the most difficult part is you can actually not, you cannot prove that you were exposed by the specific molecules of carbon dioxide, and then it doesn't make sense because greenhouse gases are what we call uniformly distributed pollutant. So it doesn't really matter whether the pollutant came from Philippines, South Korea, or Japan. The moment it reaches the atmosphere, it will create further climate change, and the impacts of climate change will happen. So what we suggest as a slight tweak in the jurisprudence of causation is, in case of climate change and in case of harm from greenhouse gas emission, the middle step, proving that the person has been exposed to a specific emission, is unnecessary. And it's aligned with the science and the mechanism of climate change. And if we adhere to the 3-step test, we will be denying a lot of real harms that is being caused by climate change. So taking a step back, what does causation even do? Why do we have causation in our legal theory? And I think that is to control what passes through the judicial review, what passes through the courts, and what is entitled to a legal remedy. And we do have a lot of sifts. We do have a lot of filters for that. We have a lot of legal theories, standings, and duty of care, the stringency of legal review. But because causation is factor from the facts, and it should be based on science. So if we adhere to what the causation framework that we have now, we will be denying that such causation exists, and that's scientifically wrong. So what I'm suggesting is that we need to adapt our causation theory into the science. And the science tells us that any greenhouse gas emission from anywhere in the world is causing the harm. So we need to expand the gate of causation. And what we need to control is rather the normative side or the policy side. And then we can look into the elements of illegality, duty of care, standing, and all these legal tests that we can control the actual policy needs of our judicial review. But we need to fix our causation tests aligned with the science. Thank you.
Okay, Attorney Youn, he's basically telling us that maybe we should push for more leniency, because right now we really are pressed to prove a causal link, although maybe still uncertain, but he's saying maybe that's not enough. Maybe we should ask for more flexibility, because it still is difficult to prove the quantum of evidence. Although we, perhaps Attorney Youn, we are more fortunate in the Philippines because we do have justices who are advocates for environment as well. Now let's listen to another expert, this time from Bangladesh. We have Justice Moumita Das Gupta. May we hear from the Justice? If she's here online. Yes, ma'am. Please share your expertise with us.
Actually, I'm from the justice so, okay. I'm trying to share my screen. So I'm Moumita from Bangladesh. I am trying to describe my views on evidentiary dilemma for filing corporate climate litigation. Actually, I was learning from the experts, but from my little knowledge, I can see that from Bangladesh perspective, actually, there are lots of environmental litigations, but not yet in court sense, there is no climate litigation till date. So, but there are some potential interpretations of existing precedents and laws that can be utilized for prospective climate litigations, but that is still to be utilized. And from legal perspective, if you see that due to different evidentiary dilemmas that my previous speakers have already explained, that it is difficult to identify the defendant who against whom I need to sue, against whom the claims are to be placed, because there are lots of corporations and there are transboundary effects of their activities. So proof of liabilities and responsibilities are really as a matter of discussion and matter to be decided through legal discussions. But these legal discussions is to be supported by scientific discussions also. But there are some scientific dilemmas also, because interpretation of scientific climate data into legal evidence is a bit tricky, because there are lack of data, scientific data, and as much as those are available, there are inadequacy climate data all over the world, including Bangladesh. And there are lack of synergies between different data. Like different data sets need to collaborate, but one data you have from a long time ago, but the other data you have just from a recent time. So for comparing, it is difficult to compare between these. And also the expert says earlier, people has thought about collecting scientific data for record purpose and for research purpose. But for litigation purpose, this is a new thought, and previously the experts didn't think about using scientific data in legal disputes, at least in Bangladesh. So this matters is still to be decided, that how we can use this scientific data in legal disputes. Again, when you say about climate change events, different climatic events, there are some additionalities. Those are barriers to prove that these climate change impacts and these impacts or these disasters are happening only due to climate change. Like you can say about heat wave, say about Dhaka or Chittagong, or large other cities of other countries like Delhi or other Karachi. At that cities, urbanization and unplanned or poorly planned development activities plays a role in increasing heat waves. And in coastal areas, when you see about sea level rise and salinity intrusion, there are people again having their livelihoods in shrimp culture. So that is also having additional impacts in salinity intrusion and sea level rise. And the other natural events, natural disaster like cyclones, storm surges, flood, riverbank erosion, and irregular precipitation. It can be said that all these are pre-existing natural disasters. But due to climate change, all these natural disasters are increased in intensity and frequency. But this increase is difficult to prove, that how far it is natural and how far it is increased due to climate change. So these are some dilemmas from scientific aspects. And then, so if we can see the existing practices of different countries and international perspectives. So RWE case, that is a very famous case from Peru that is filed in Germany, but it is not yet decided. Holcim case from Indonesia filed in Switzerland. It is also not yet decided. So how far these evidences will be accepted by the court, it is yet to be decided. The decided one, the Philippines National Human Rights Commission, it is a huge work resulting into recommendations, but that has doesn't have any binding force. But that recommendation is also important because it is a good start to impose liabilities and responsibilities through further proceedings. So in other countries also we can see this as a precedent, but still we need to utilize this from our national perspectives. And from recent advisory proceedings of different international courts, ITLO's advisory opinion is decided, and it is a great achievement. It is being discussed from yesterday, so I am not going deep. And ICJ advisory opinion, it is still pending, but submissions that are made by the states are not easily accessible. So we cannot see how far these are progressive or not. And IACTH, Inter-American Court of Human Rights advisory opinion, that is also pending, though that proceeding is not binding for Asian countries, but that has persuasive value on the Asian countries' jurisdictions. And though it is not yet decided, the submissions made at that proceeding is highly progressive submissions. So we can have look to those submissions. There are different legal explanations and scientific explanations also, scientific backgrounds also, and that is very vast and very I can say optimistic submissions are those being submitted by different countries or different organizations. So in this background, even from Bangladesh perspective and other perspective, we can see that we need research and scoping for climate litigations. We need attribution study based on climate data analysis. We need feasibility study based on desk review and field studies to see how climate change are impacting from sociological aspects, socio-ecological aspects, socio-economic aspects, and socio-legal aspects. This can be supported by audiovisual documentation or audiovisual documentary, and all combined, this research study can have an output to determine the way forward to bring up any climate litigation in any country or any jurisdiction. So this requires expertise and long-term efforts and resources to proceed on. So these are my findings, or these are my views. So looking forward to learn from you more. Thank you all. Thank you.
Moumita Das Gupta, and here she has given us recommendations, and what I gathered really is the emphasis on scientific evidence, but also the component on human rights, as Attorney Labog has explained to us, the importance of research on incorporating or at least recognizing the human rights aspect of climate change litigation. Now, we have very few minutes to wrap up the panel. I'd like to ask Attorney Froy, may we ask our panelists for their 1 minute closing remarks? Kasi we can no longer really accommodate questions. Oh, we are extended. So, yes.
Your motion for extension has been granted.
Thank you, Your Honor. So, yes, so I think we can, if there are questions for our panelists, or perhaps we can now ask our panelists to give us their statements after hearing all the presentations. So, let's follow the same order before. And we would ask Dr. Jem Castillo, sir.
Thank you, Attorney Donna. The one that came to mind is the precautionary principle, and that's one subject that we have in environmental economics when I was doing my PhD. And the question really there is, when do we know the threshold? When will the threshold happen? In our last webinar of the Environment and Economy Group Philippines, there was a presentation on because our target is to maintain the temperature at 1.5% level, but apparently it's growing beyond the 1.5 degree centigrade temperature, and so we are actually saying that the current solutions being done globally in terms of reducing greenhouse gas emissions is no longer feasible. You have to spend more. And then even the proposition was to actually to do some aerosol reduction in the atmosphere through some flying stratospheric planes and reducing or spraying aerosols or something that will reduce greenhouse gas. And the other is also that we need to now, in the Philippines case, because we're now being subjected to intense rains and frequent rains, there is now that option for us to really do some ocean drastic moves at the ocean level in terms of doing some activities beyond what is the current global arrangements of reducing greenhouse gas. The net zero emission reduction targets is already beyond us. So that's what when we talk about precautionary principle, because it's really asking the question, do we know the threshold? We had the same study in, for instance, in Laguna Lake. How do we know that the pollution in Laguna Lake is already irreversible? What are the indicators? So from the economics perspective, you have to determine what are indications that is already irreversible. Is it the biomass of the fish? Is it the parts per million that will make it impossible? In fact, even any amount of investment will not make it even to grade A level, because right now Laguna Lake is grade C, meaning it's not even worth for bathing and so on. The other one is the issue of whether we should go into infringements, right, just as our attorney from Japan was saying, or really discussing about health impacts on our economic activities. So any anthropogenic activity, should we go in the direction of infringement on rights, or should we just more specific, measurable impact on health, impact on crop yield, impact on infrastructure damages? These are all questions that has to be addressed and quantified and monetized if you are to deal with compensation. And the other one, of course, is the issue of how much is the contribution of a company to greenhouse gas, and how should we compensate people who are affected locally? Because right now we think of the atmosphere as a global or a public good, meaning maintaining the level of greenhouse gas is a public good that no one would like to invest in individually. And so the issue of negotiation among countries in terms of investment has to be, and then there's always that opportunity for people to do free riding, meaning no one wants to invest in maintaining the greenhouse gas in terms of its current level of fluctuation. And so the question now is addressing this by quantifying the carbon emissions of each company and translating them into monetary terms so that they can convert it into costs or expenditure, and requiring them to do an offset, meaning if their emission is way beyond their capacity to reduce, then they have to pay or compensate for additional emissions out of the. So that's the idea of the net zero emission, and that's what we want to quantify and come up with specific measures. That's the idea for the integrated assessment models. Coming up with quantifications, and then the next step for the compensation part is really for economists to see value. The next question right now is the social cost of carbon, it's just actually measured every year, sufficient? And a number of litigations have already used the social cost of carbon as a means of quantifying and measuring the monetary value of emissions by companies and corporations. I think that's, from my perspective, my summary for that. Thank you.
Okay, thank you, sir. We will ask Professor Rommel. We're hoping you can give us more of your first-hand knowledge of the precautionary principle, again, as mentioned here. Sir?
Okay. I wasn't planning on talking about that, but since you asked, well, when you talk about the intent of the framers, then what we really need to take a look at would be the intent of the Supreme Court justices at that time when they enacted. I prefer calling it the Green Rules. A few years ago, I wrote a paper outlining my observations on the environmental rules of procedure. The title is Green Rules, Gray Areas, and Red Flags. While it was still fresh on my mind, what went on in the deliberations. But going into the precautionary principle, what happened that time, I can only speak for myself and my principal, who was then Dean Youn. And what we really wanted was to make it easier for environmental litigants to be able to proceed with their cases, similar to the problem which res ipsa loquitur is supposed to solve. Since it is the corporation that has all the evidence and all the money, then they should be the ones with the responsibility of proving no harm, rather than the poor litigants trying to prove the existence of damage or harm. So that was the intention. I think the original plan was to push for a burden shifting similar to res ipsa loquitur, but that was not accepted by the majority. And as I mentioned a while ago, the version of the precautionary principle that was was accepted was the wingspread version, and not wingspread declaration version, and not the Rio principle version, which I think can create some problems, as we can see from the litigation, mainly because it seems to go against the rationale behind the precautionary principle in the first place. The rationale of the precautionary principle is to lessen the significance of scientific uncertainty in these types of cases. But when you make scientific uncertainty an element in order to trigger the precautionary principle, then you certainly do not lessen the significance of scientific uncertainty. So what I was, the other thing is there seems to be a shifting of a focus, because what seems to be the focus in cases invoking the precautionary principle is there scientific uncertainty? Instead, the trigger should be, is there serious or irreversible damage? That should be the trigger, not whether there is certainty or not, because if you prove the existence of serious or irreversible harm, then the precautionary principle should be triggered, in my opinion, regardless of whether there's scientific uncertainty or not. So I think it's possible, even despite the way the rules of procedure environmental cases is worded. As I mentioned earlier, we have so many statutes that refer to the precautionary principle. And I'm thinking, can't it not be argued that when these statutes refer to the precautionary principle, they're not necessarily referring to how it is defined in the environmental rules of procedure, which sets a very high threshold? Can it not be argued that these statutes are actually referring to the precautionary principle as accepted as a general principle of law, which has a lower threshold and has a simpler effect? And it doesn't trigger the dangers that Justice Youn mentioned about citing Cass Sunstein, about the possibility of no action ever being taken because of the strong version. I think also that the lack of scientific certainty is really just on the causal link between the activity and the harm. Because sometimes when I look at the cases, the scientific uncertainty is about whether the plaintiff is able to prove that this particular activity will cause the damage that they are alleging. But that's exactly what the precautionary principle is obviating. What is required, yes, there should be evidence, there should be scientific evidence, and the work of Dr. Castillo and others like him, it's very important, because you need the scientific study to prove the existence of serious or irreversible harm. What you don't need to prove is that that particular activity will cause that specific serious or irreversible harm. For example, a plaintiff can argue that this particular oil extraction activity in my city will cause irreversible harm. How does he prove it, or how does he invoke the precautionary principle? Just provide studies, even from other places, where oil extraction activities are causing that kind of harm. He doesn't have to prove that this particular company is causing this harm, because that would be scientific certainty with respect to a particular actor. All that the plaintiff has to prove is that there are studies that show that oil extraction activities elsewhere can result in this type of harm. Therefore, the precautionary principle will apply. So the plaintiff does not have to prove that this particular actor's particular activity will cause harm. That's exactly what the precautionary principle is for. And lastly, there's an option for litigants. Do you choose tort law or human rights-based cases? It's a double-edged sword. I mean, if you use tort, the rules are simpler, I think. It's established. Causation could there are many rules on causation. Besides, causation is just who do you blame? And in tort law, you don't actually have to prove that person A actually caused it. In tort law, you just have to prove that under the law considers person A to be responsible, regardless of whether he's the actual cause or not. So that's the simplicity of tort law. But but the problem with tort law is it's not as elegant or as noble as a human rights case, which can tug at the heartstrings of the justices or the judges. But it's harder to prove because of the complications in human rights law. So I'm not an expert there, so I will leave that to Pochoy. But so you have there are many possibilities for climate change litigation, and I better stop now before I end up doing a lecture.
That leads us to Attorney Pochoy. Please, sir, to react also.
I think the market share theory in tort law is such an innovative way of sort of assigning liability to defendants in a particular climate case when a defendant cannot be, specific defendant cannot be identified as the perpetrator. There's this market share theory that just divides the liability among, depending on the market share of that company, which can be applied in theory to climate change litigation. But I guess for my closing remarks, I'd just like to highlight what the diagram that was presented to us by our panelists from South Korea, which is a better graphic compared to mine, that shows the difference between an environmental case and climate case. With the environmental case, again, just to emphasize that the links are sort of clearer compared to a climate case because company A, coal company or mining company, an oil spill or a mine spill happens, and it affects a certain town, certain community. There's that relationship. With a climate case, there are carbon emissions, and it causes the Earth the climate to be warmer, and it triggers certain events that impact communities. So again, just to emphasize that's the difference, and it may require again the close collaboration with scientists. I wish we can have that lower threshold and take into account the precautionary principle. I'm not aware of successful climate litigation when it comes to damage and liability cases, but that would certainly ease the burden of the claimants. And the other thing I would like to emphasize is climate cases are the definition of a transboundary issue. Again, the most carbon emitters, the heavy carbon emitters are in developed countries found in the global north. So they contribute the most carbon emissions and contribute more to climate change than the Philippines or developing countries can ever do. And so the exacting liability will require this transboundary coordination with courts, lawyers, which poses a significant challenge, although there are certain developments also that are happening in human rights law, the corporate sustainable due diligence directive in Europe. There's the French, I mentioned the French duty of vigilance law, German supply chain law that have extraterritorial application. If this can be applied in climate cases, then things will be better for claimants.
Mike, to you.
Sorry, I can't. I'll have to take advantage of this panel right here. And this afternoon, we're going to be talking to judges about climate litigation. And I want the expertise in this panel could help us tell them how to approach these cases. I'll proceed from the transboundary aspect comment of Attorney Pochoy, because in many cases, that's a cognitive constraint on the part of our courts. And there you have all those questions about attribution and causation. So how should a judge looking at a climate case approach using, with all these tools, without confusing them in how to use precautionary principle or attribution science? What is the baseline premise or approach that a judge should take in looking at these cases to avoid the traps of that doctrinal way of looking at things element by element? If it can ever be reduced to a guidepost, what do you think should we tell judges looking at cases like this? And we can learn from our panelists on stage and also from other jurisdictions who are helping us today.
Thank you, Attorney Mike. And I think we will hear from our Japanese experts. They were actually discussing how it is in Japanese litigation. So may we hear first from Attorney Kita.
Hi.
Yes, sir. Attorney Kita, we can see you. Perhaps you can already share your closing remarks. And it is really about, for us, everyone to hear from the Japanese experience how you are dealing with a greater transboundary effect, but you are filing cases in Japan.
Oh.
Okay, Attorney Kita, we will give you time, but I think Attorney Kojima can really give us pointers on how to deal with this transboundary effect of climate change, as he has already discussed in his presentation earlier. Attorney Kojima, please, sir.
Yes, the question is how to attribute to the responsibility to a particular facility, particular person who emitted a lot of carbon dioxide. Because I think the biggest facility emit less than 1,000th of the global carbon dioxide emissions. So, under Japanese court standard ideas, all those facilities are under the threshold. So, under that theory, any big facilities cannot attribute to the global carbon dioxide emissions. So, not any facilities, we can't sue any particular facility under that theory. It is a big question. They use the word significant. Significant. Under the word of significant, they put all the facilities under the threshold. So how to overcome that kind of question is our big problem. So today I heard the discussion from Philippine professors. I'd like to adapt those theories. And the other theory is today I already presented the last Storo theory. Already the concentration of carbon dioxide in the air is very high. So even a small emission can contribute to the change of global climate. So it will contribute the increase the danger of global climate change disaster. We have already proved a lot of cases who suffered from the climate change in Japan, typhoon and heat shock, big reduction of fishery in many cases, and even the court admit the climate change threat is very severe. But they did not want to admit the causation between a particular facility and those climate change threat. So it is a very big question. So how to overcome that question? It is a big question, so we'd like to learn a lot from your discussion. That's all. Thank you.
Sir, Attorney Kojima, perhaps we can hear from Attorney Kita. Sir, would you like to add to that statement?
Hi, thank you for the time. I thought the Japanese judge have a difficulty to make decisions that have an impact on policy and international impact. They may not make a decision because it's the international impact. However, I believe that this is a human rights issue, and I would like to be addressed for Japanese judge. Thank you.
Regarding the human rights, climate change, more expanded challenge than what we have in tort law. Attorney Youn, please.
Thank you. As we have heard from various panels, I think the theoretical advances in dealing with causation and contributions, the attribution science of climate change is advancing very quickly. It's the court that is not really used to this new language and these new models and approaches, and they often tend to adhere to their classical ways of dealing with it. So repeated attempts to argue these claims and cases in the courts, I think it's also a iterative process that we educate the court, we familiarize the judges with this new mechanisms of climate change. I think that's what really makes the change. And in regarding the transboundary effect of climate change, it's in nature transboundary, and I think it really helps the narrative of the cases to really bring in victims of climate change from outside the country into the country where major emissions happen, as the case has been in the RWE or Holcim case presented by Moumita. And we did have some cases we had the plaintiffs from Indonesia come to South Korean court to argue against a planned investment on coal power plant. So I think the transboundary nature of climate change litigation really helps to the narrative and the legitimacy of the claims. Thanks.
We have actually exhausted our time, so may we ask Attorney Casis to give us, if you have any further recommendations. So we beg your indulgence, ma'am. We have been told that we have to say thank you, but we have Attorney Casis to tell us, sir, a last advice to everyone.
Okay. Maybe to answer Mike's question a while ago, perhaps to help judges. It's very difficult for an ordinary lawyer to imagine how he can assign blame to a corporation for something that is done by everyone and it goes through the medium of the climate and affects a particular person. And I'm not sure if we can go beyond the doctrinal, Mike. However, what might help would be to apply an analogy that ordinary judges should be able to apply, which again would be tort law. Imagine a multiple collision involving several vehicles and one person is injured. How do you attribute who should be blamed? And tort law provides for rules. You can apply many rules. You can apply substantial factor, but-for test. But I think for the climate, it should be substantial factor, which has not been used in Philippine law, but it can be applied, provided that you contributed a significant amount to the problem. You don't have, that's how it is in tort law. In tort law, you don't have to prove that this particular person actually caused the harm. The law points the blame at that person. Under the law, you are to blame, regardless of whether factually you really did injure that individual in that multiple collision scenario. So I guess similarly, the law can be applied that way in climate litigation. We do not have to prove that this particular corporation causes particular harm. The law just simply says that because you are a corporation, engage in this activity, and because you contributed, then you should be liable for the damage. So apply tort law analogy to make it more imaginable for everyday practitioners. So that's, I guess, my final word.
So thank you. That ends our panel. Attorney Froy.
Thank you very much. So that was quite an extensive discussion, very informative as well.